Good morning. Thank you both for coming to this early session. No, in all seriousness, thank you very much for coming at this early session on the final day of CPDP after an after party that I understand went quite late last night. I'm Neil Richards. I'm the director of the Cordell Institute at Washington University in St. Louis and a law professor there. And I'm delighted to welcome you to our morning panel, AI Regulation and the Limits of Data Protection. Our concern today is to talk about the relationship between data protection rules and everything else having to do with the digital world that data protection regimes are increasingly being asked to deal with. In a very real sense, this is sort of the theme of CPDP over the last 4 or 5 years. It's perhaps why the .ai got added to the back of CPDP's name. And the problem is essentially this, right? A few years ago, or for those of us who are a bit older, 20 years ago or even more, data protection law was a very discrete, insular, unknown, boring, small field. Well, it was never boring, but it certainly was not considered to be exciting. And then we had this internet thing that made it seem rather relevant. And as the internet and digital technologies increasingly took over more and more aspects of human life, and human data was involved in fueling much of this transformation, as we all know, data protection law became increasingly salient, increasingly important, increasingly known to lawmakers and policymakers and even ordinary people. And it wasn't just the we have updated our privacy policy for GDPR compliant emails that we all got some years ago that caused that rise in recognition and importance. But of course, in recent years, particularly with issues like political misinformation, deepfakes, artificial intelligence, digital discrimination, legal regimes like the GDPR and its analogs around the world have increasingly been tasked with dealing with these other problems that involve and implicate human information, but that aren't typically the sorts of things you might think of as data protection problems. For example, when we think about artificial intelligence, is this something that organizations like the data protection authorities or the EDPB should be primarily tasked with dealing with, or, as the European Commission or European government determined, is something like the AI office the best way to deal with these sorts of problems? So in a very real sense, our topic has to do with the success of data protection law, data protection frameworks as a regime, and some of the problems associated with that success. Has it become too successful? And at what point in digital issues do data protection laws and expertise and frameworks end? At what point should other frameworks begin? And what should those frameworks be? And what should the relationships be between data protection and those frameworks? And so I'm delighted to be joined by an eminent panel of people who are also quite delightful. And though I know all of them very well, their titles are sometimes quite arcane, and so I have my notes to do that. So starting on your left and moving to the right, we first have Woody Hartzog. Woody is a professor of law at Boston University. Then we have Claire Boin, who is a postdoctoral research scholar and lecturer in law at the same law school that I teach at, Washington University School of Law in St. Louis, Missouri. Then we have Carolina Foglia. Carolina is the head of sector for legal affairs, cooperation, and enforcement at the Secretariat at the EDPB. I love the pairing of cooperation and enforcement in Carolina's title. It's just sort of like, you can agree with us or we're going to punish you. And then finally, we have Orla Linsky, who's a professor of law and technology at University College London. And so our brief, I'm going to sit down and we're going to have an interactive chat on the sofas, on the soft seating. And each of the speakers is going to go for sort of 5 to 10 minutes, and then we'll have some discussion among the speakers, and then we'll, as a reward for you all getting up early and dragging yourselves to CPDP before 9 o'clock in the morning on the final day, we're going to hopefully work in some questions from the audience. So it's a fairly standard fare for CPDP. So we're first going to start with Woody. Oh, Caroline, I'm sorry. Carolina's going to go first.
First challenge was checking on the mic, so it works. Hello, everyone. Indeed, thanks so much also for inviting me. It's really great to discuss this point that I feel very strongly about. I hope I will convey my strong points here, even if it's very early in the morning, and I'm not really much of a morning person. Indeed, as Neil was saying, I work at the Secretariat of the DPB. I lead one of the 2 legal teams there, focusing indeed on cooperation and enforcement. So my main point, the main point that I would like to make is that, as you might imagine, data protection law does provide very useful and powerful tools to deal with the challenges that are brought by AI. Of course, this doesn't mean that it's the only tool that we can use as society, but it does provide very powerful tools. I'll make 3 points. On this, the very first one, although it might seem obvious, it's really not obvious in my view, and it's important to bear it in mind. The GDPR was created to protect fundamental rights in the understanding that processing of personal data is meant to serve mankind. And there's this overarching basic assumption that the GDPR applies when there's personal data involved. These personal data are connected to people. And so data protection law in itself, in my view, serves as a reminder that it's really people we're talking about. So not all problems can be dealt with by technology, luckily, and I think it's important to bear this in mind. But even where problems can be dealt with by technology, it's important to remember that it's people we're talking about, and it's really human problems we're talking about. And so when there's processing of personal data, in my view, the requirements of the GDPR and of data protection law at large really serve as a very strong reminder for everyone involved that it's people we're talking about. And so it's really apparent, in my view, in several of the provisions of the GDPR that the human being is at the center, And we have several obligations. We can think of the principle of fairness, which is a broad concept, but that has been really interpreted to mean that processing of personal data shouldn't harm the data subject. It shouldn't be detrimental, it shouldn't be misleading, it shouldn't be discriminatory, and this is quite powerful. Also, we have, of course, the other principles laid out in Article 5. We have transparency, and I think in the field of AI, it's important to underline that as much as the technology is very complex, there's still an obligation under the GDPR to explain this to data subjects and to really make them understand. And so maybe more creative ways of explaining this should be found. Although this doesn't mean that the data subject can be given the responsibility of ensuring that they are protected. This responsibility is really on controllers and processors. Of course, the principle of lawfulness also plays a very strong role on this. As you know, there's no hierarchy among the legal bases laid down by the GDPR. If we look, for example, at the legitimate interest legal basis, which is very much discussed in the field of AI, we can see that in the balancing exercise that controllers are requested to carry out, there's really a need to check the impact on data subjects and on their fundamental rights more broadly. So again, this to me shows how the GDPR really puts in place a number of requirements that put the person at the center. This is the case also with privacy by design and by default, and also with DPIA, which of course, again, entails an assessment of the risks for data subjects. Another important point is that the GDPR obligations are dynamic. So sometimes we can say they're vague, but actually this vagueness is a feature because it allows these provisions to be technology neutral and to apply to any type of processing and to apply dynamically. And also it means they're dynamic in time, meaning if the controller changes its processing of personal data, compliance with the GDPR needs to be reassessed. A new DPAA may have to be carried out, and so on. A second point is that right now, the powerfulness of data protection law is also shown by the many actions that are being undertaken by the EDPB, but also by individual DPAs. The EDPB has issued an opinion in December on AI models covering some fundamental questions. It was a selection of questions, as you know, because the EDPB was requested to reply to these specific questions by the Irish Supervisory Authority, but the EDPB is also working on further guidance on AI, specifically on web scraping, for example. There's also a lot of work ongoing on enforcement. We have several one-stop shop cases that have been opened. There's also some non-one-stop shop cases that you're probably all aware about, but we can also discuss a bit. The Italian DPA has been very active on OpenAI, more recently on Replica. There's been several fines imposed on Clearview AI in Europe. And the EDPB is also engaged in supporting enforcement and cooperation, as Neil was underlining, among data protection authorities. For example, a task force initially on ChatGPT and then more broadly on generative AI was set up really to help DPAs join forces and coordinate on these non-one-stop shop cases. It's also important to bear in mind that AI is a global issue, very clearly, and so the EDPB is also engaged in a more global dialogue, for example, in the G7 and so on, in order to really foster a shared understanding of these issues more broadly around the world. Then, as a third and very last point to start with, of course, as Neil was mentioning, in Europe, the GDPR isn't the only piece of legislation applying to AI. We also have the AI Act. And the way, in my view, they should be seen is really in a relation of complementarity. So, of course, the GDPR doesn't tackle all possible issues. Probably the AI Act also doesn't. But they should be seen indeed as two pieces of legislation that are to be coherently interpreted. There's a lot of work ongoing on this. The EDPB and the AI office will closely cooperate on providing guidance on this. And the AI Act has a bit of a different approach. I know that this has been discussed at CPDP at length. It has more of a product safety approach. The GDPR is more clearly of a fundamental rights approach, but the two tools combined can really, in my view, provide a very strong safeguard for data subjects and for individuals. So, yes, I would say the future looks bright, even if difficult and with challenges. Yes, and so this would be it from my side. Thank you very much, and I'm happy to further discuss.
We'll go forward at the end. Yeah. Woody, do you want to go next?
Sure. Thank you all for coming early this morning. So thank you, Carolina, for that really great introduction. So I want to begin. I'm going to be bringing a little more of maybe a critical perspective on data protection, but I do want to take a second and recognize that at least from a U.S., someone from the U.S. Looking at what's been happening within the EU and around the world in data protection. Data protection is actually one of the very few frameworks that has been working at all in terms of trying to produce any sort of meaningful accountability. So I want to recognize that before I launch into why it's insufficient and not going sort of far enough. And so as a matter of, and I just want to make sure my time's okay, as a matter of theory, when thinking about whether data protection is up to the task of responding to the challenges of artificial intelligence, there's a couple of embedded assumptions about the entire data protection approach that are worth challenging. One of which is the entire GDPR and a lot of the rules in the United States seem to be implicitly, if not explicitly, premised on the idea that data processing is most of the time a worthy goal. In other words, we want to facilitate data processing. And we want to have rules for the safe and sustainable processing of personal information. That's why they're called the fair information practices. And one of the things that I would like to tease out about artificial intelligence, because I've been relatively critical about these systems, is that I think it's worth challenging the assumption that AI systems are inherently desirable or worth chasing, right? One of the best things that I think that the GDPR does is require at least a legitimate basis for the processing of data. And I'd like to see a little bit more of that skepticism overall for artificial intelligence. The creation of data is a moral act, and we should treat it as such. And the idea that it is sort of uniformly desirable and we just need to set up guardrails, I think is, it was maybe flimsy to start with, but certainly is significantly less tenable in an age where we've seen all of the harm that can come from the massive processing of personal information and the power that that confers. You all have been on the internet for any sufficient amount of time to understand sort of where we are and how far that's gone off the rails by embedding a sort of presumption of virtuousness with respect to both the processing of personal data and AI systems. Scraping is a great example of this, so I do want to give credit where it's due. Dan Solov, who's my co-author on a paper about data scraping, who was here a second ago, but I guess when I started talking, he left, which happens sometimes. I get that a lot, particularly from Dan. Oh, is Dan here? Okay. Oh, yeah. Oh, there he is. So we wrote a paper relatively recently that said that scraping is actually fundamentally incompatible. The scraping of data to train AI systems is fundamentally incompatible functionally with the entirety of data protection law. And there have been some moves in that direction. I would like to see a little more aggressive embrace of that, because if you take the fair information practices on their face, then it is actually functionally incompatible with scraping of publicly available data for training of AI purposes. And so that is an area where I think that the beginning part, the data part of training AI systems is actually holds great potential and has started to be relatively effective. The second point that I want to make is that while the GDPR and the US data protection laws are very good about covering regulations around the idea of personal data itself, I don't think that they have, as of yet, been interpreted in ways or created in ways that are sensitive to power differentials within relationships and the concept of scale. And I'll start by saying I do understand that there are certain aspects of the GDPR, the fairness requirement, for example, that are sensitive to vulnerabilities. The legitimate interest legal basis processing requirement can be sensitive to power disparities within relationships. But the main focus of data protection law is, in fact, the unit of data, right? And that's actually one of its virtues, the fact that the protections apply irrespective of the relationship that matters. But when it comes to AI, we are on the bad side of one of the grossest power disparities that you could possibly imagine. These are the most powerful companies ever to exist. And we have the most intimate relationship with these companies that you could possibly imagine. They know us better than maybe even our partners know us, given the number of times we check in with them more frequently than we do with our partners. We have an elongated relationship with them. I mean, these companies want to be with us until we die, which is longer than most personal relationships we will have in our lives. And so the idea that this is, that all sort of relationships are the same, particularly as AI agents start to get embedded in every single aspect of our mediated technology, I think that we need to start to be more sensitive to the idea of power disparities within these relationships. And Neil and I have written at length about ideas of duties of loyalty and fairness, and how that could actually bring a significant new framework in to think about our relationships with AI companies, but also this point of scale. So one of the things that I like about data protection law is that it applies if you're processing functionally any amount of personal data, that there's no sort of threshold. But then one of the things that it sort of lacks is a sense of the power and the scale at which these major technology companies operate. And our legal frameworks, and I think the data protection law is a little bit like this, tend to treat scale as though the more amount of something is a worse amount of something, right? So if one instance of a violation is bad, then 100 instances of that violation is 100 times as bad, or 100 instances more worse of badness. But scale doesn't always work like that. So the bigger things get, the more involved they get in our lives, it actually could change the nature of the problem. It could change the number of the solution set that's available, or take some solution sets off the table. And so, there's an argument that the accountability mechanisms that are currently built into even the GDPR, which has some of the most robust finding mechanisms around, are insufficient to tackle the power, the incredible power of these amazing platforms, that they're easily able to sort of take all of the fines that are generated across every single data protection framework in the world and just make it the cost of doing business. The business model, which of course then remains unaffected largely by data protection laws, and as AI companies build their business models on the exact same exploitation of human resources, I don't see that the existing frameworks really meaningfully pushing back against that. I just want to make sure that I'm doing okay on time. Okay, 8 minutes. So just two more quick points. One of them is one that one of the strengths of data protection law is that it is built around one of the reasons, the main things that it is built around, if I'm understanding data protection law right, is informational self-determination, which is sort of dignitary rights. But when it comes to AI systems, informational self-determination isn't everything, right? And so what I worry about is when we ask data protection law to do all of this heavy lifting with respect to the regulation of AI systems, we're asking it to do too much for a system that was not meant to respond to all of the harms that we are now seeing as AI systems come into play, things like attention theft and the ability to sort of inability to concentrate for any sort of meaningful period of time, labor exploitation, right? So the mass sort of extrapolation of all of our labor for other people's efforts in ways that we don't even recognize. My colleague at Northeastern, Hillary Robinson, called it a factory in every pocket. De-skilling, right? So this is one of the major worries that we think about as automated systems get implemented. I don't know if data protection law has much to say about de-skilling. The erosion of the public sphere and public discourse as misinformation becomes rampant and the cheap generation of plausible sounding text becomes rampant. I don't know how much data protection law brings to bear on that, and the erosion of sort of critical thoughts. And control, informational self-determination might not even be the right goal, and Neil and I have written about this, might not even be the right goal for data protection law. Control is illusory. It's not like real control is ever possible in a mediated environment where all of our choices are sort of pre-selected for us. And Dan and I have also written about this. It is overwhelming, right? So that the number, I teach a introductory privacy law course, and the very first thing that it comes out every single year that my students hate the most is cookie banners, right? And we all have heard 1,000 jokes about cookie banners, but it's overwhelming at scale. It's like a DDoS attack on our brains, and it's illusory, right? It's myopic. The idea that choice is the thing that we should be controlling, when what we really care about is the abuse of power. At least if you understand privacy like I do, and I think that Neil and maybe others in this room do. And then finally, one of the things that this may be more popular in the United States, but a lot of the data protection frameworks that are popping up now in the United States, particularly around the concept of data minimization, are basing their rules around the concept of reasonable expectations of privacy. And I worry a lot about basing all of our rules around reasonable expectations. I think it's a broken test, but one of the things that technology law has been very poor in resisting is the idea of normalizing all sorts of problematic behavior over time. And when you base your legal threshold on whatever it is society can be conditioned to tolerate, then you just keep moving the threshold down, sort of further down. It started off that CCTV cameras were alarming to us, and now they just blend into the background. Facial recognition is still sort of alarming to us, but over time, as every single time we go to the airports, our face is scanned. Every time we pull out our phone, our face is scanned. Society will become conditioned to being watched and to becoming more exposed bit by bit. And I don't know how much data protection law or even the AI Act takes seriously the idea of being normalized and acclimated to these technologies in ways that deprive society a meaningful opportunity to actually debate these technologies on their merits. Rather, we say, oh, well, society doesn't think it's a problem, therefore it must be okay, right? And if you make the rule that what's against the law is whatever society rejects, and then you say, you have a situation where society is prepared to accept everything over time, right? We don't see it happening because it's dispersed and it happens over time. And then finally, I just want to say one of the real problems, and I don't know about data protection's answer to this, one of the real problems from AI systems is tech oligarchy, and the idea that all of this power is concentrated in an incredibly small number of people. And to fight tech oligarchy, you're going to need more than the GDPR and the AI Act. You're going to need corporate governance reform, right? Part of the problem is that the dual class sort of stock structure that allows Mark Zuckerberg control over Facebook means when he gets his feelings hurt, it's everybody's problem, right? And so we need tax reform, right? We need to move to the level of infrastructure. We need to move to the level of design. And I'm not sure how much Article 25 in the GDPR is sort of built to respond to a lot of the design interventions necessary to really sort of to build this out. And so this is just a few thoughts on even though I think that the GDPR is one of the few things that actually has created any sort of accountability, I think there's a lot more to go because the threat of AI systems are so large and different that it's worth talking about making sure that we're not asking data protection to do more than it's capable of. Thank you.
Thank you, Woody. Claire?
Thank you. My main point today, which is going to sound a bit contrarian, is that we should not be having this conversation at all. I think that we are used to lumping data privacy and AI law together because they belong to digital law, because it's mostly the same people working on both. But I think it's been misleading to the field of AI law. And to be clear, I am very supportive of data protection. I think it should go further. Same with AI law. I just think that lumping them together hasn't been as productive as hoped. And I'm going to say this in 3 arguments. The first one, I know has been made many times within these walls, it's that data protection mostly relies on fundamental rights and therefore is mostly individual-based. And we often talk about the limits of that even in data protection itself. So several people on this stage, for instance, have worked a lot on the fiduciary duties applied to data privacy, and especially the duty of loyalty. And the reason for this is because data privacy is often a relational and a collective issue more than an individual one. And if you think of this, I think the textbook point about this is the question of inference. How if you collect someone's data with their consent, you can then use that data to make inferences about someone else who hasn't given consent. So the textbook case showing the limitation of the fundamental rights framework or individual rights framework to data privacy is really what we call AI today. Because these sort of inferences, even though we were not calling them AI 10 years ago, now we do actually. And AI systems today are mostly based on induction and inference. So I think that, unfortunately, many harms caused by AI systems today are more collective and relational than individual. So other examples of this are they go to Woody's point about scale, right? They are things that may not be harmful at the individual level, but they become harmful when you scale them up, such as large-scale automation, concentration of power, the impact of AI systems on the environment, large-scale persuasion that can sway an election or sway society in a direction. And so these are effects of AI that happen in aggregate. And I don't think that a fundamental rights framework is suited to address this. My second point is that, and this is, I think, a less talked about point that I like to write about, it's that we often think that most AI harms come from data sets, but there's so many different harms of AI that do not come from a data set. Even if you have a well-balanced data set, even if you have a representative data set, even if you have a qualitative data set, you may still have serious harms from AI systems. So some of them may come from the reward function. You can think, for instance, of a diet app that would progressively be recommending more and more harmful diet and more extreme diets because it would maximize user engagement. Or similarly, reward functions on Instagram and Meta and social media that contain addictive features. You can think of LLMs like ChatGPT being used to create malware because they're dual-purpose technologies that can be used for good and for bad. It's not really a problem with the data. Also, if you think of chatbots, many of the harms today, such as inciting self-harm, or there's been this example a few years ago of the Replica companion app in the UK that helped someone make a plan to kill the Queen of England, and that person was arrested. Obviously, they didn't succeed, but they made that plan, they hatched that plan with their Replica companion. And the reason for this, or the reason that LLMs like Character AI and others also nudge people towards self-harm is not because necessarily there is data like that in their training data. Most of the time, it's actually because those systems have been trained and reinforced to validate users. So because the purpose is to make users feel good about themselves, they're supposed to validate the user's sentiment. So if the users start going in that direction, the AI system is actually going to reinforce that, which obviously is very harmful. So my second point is that we should think of AI harms as more broadly than data harms and data created harms. And then I guess my third point is that there's no such thing as a single AI system. We've also lumped together many different things when we talk about AI. And again, the statistical tools we used 10 years ago, sorry, it's not going that fast. The statistical tools we used 10 years ago for assisted decision-making, we didn't label them as AI at the time. I think we have since, for hype, basically. It's in companies' interest to sell them under AI. But these tools, the ones that the AI Act originally aimed to regulate, maybe they were more suited for fundamental rights frameworks, and maybe most of the harms that could cause actually came from the data. So when you think of these narrow algorithms that are supposed to be applied for a specific decision-making process or in a specific field, such as the ones that are considered high risk under the AI Act. However, if you think of generative AI, which is a completely different story and general purpose, I think the previous 2 points I made really apply there. And the fundamental rights framework, even though it is crucial to also have it, is absolutely not sufficient. And in the same way, it's not sufficient to regulate the data in hope that it's going to prevent harm from those systems.
Thank you, Claire. Orla?
Thanks. Good morning, everyone. I'm going to start this morning with I guess, two kind of preliminary points, just building on what colleagues have said. So the first is, my starting point when I think about systems of automation or AI systems is that they have kind of three key ingredients: information or data, or that kind of informational component, an infrastructural component, access to the relevant tech, data centers, etc. And then, I suppose, kind of access to the right epistemic resources, the people needed in order to develop these systems. And clearly, data protection law is only going to intervene at the kind of informational level. And so, in that sense, its role in regulating AI systems more generally is de facto limited. I also, as a second point, think that data protection, as Carolina said, while the regulatory target might be data, the regulatory objective is to protect fundamental rights. And that is to protect fundamental rights rather than, the rule of law or democracy more generally. But I would see as a prerequisite to achieve those other public goods, the protection of fundamental rights. There will be no democracy without privacy, without adequate data protection. And so, kind of against that backdrop, and for, thinking about our discussion today, I think there are three features of the data protection or privacy framework that are sometimes characterized as failings, but that become particularly pertinent or salient when we think about AI systems. So maybe one more preliminary point. I think an important thing about data protection is that it's on the books. And at this moment in time, I wouldn't kind of take for granted that we would manage to achieve to have another law as expansive, as protective as the GDPR adopted, given kind of prevailing political winds. The other thing is, similar data protection frameworks, albeit to greater or lesser levels of prescription, are enacted in over 130 countries worldwide. So, I'm reading and marking student essays at the moment, and one of my students described data protection law as a first line of defense for AI. And I think that is particularly pertinent in this context. But then, these three features or failings, what might they be? I think one feature is flexible principles, which Carolina has already kind of referred to, that dynamism that you find in data protection law. Another feature, sometimes referred to as a failing, is its diversified enforcement. And a third feature, again sometimes referred to as a failing, is its predominantly individualistic approach to the protection of rights. So I'll go through these in a little bit more detail. If you stripped data protection law back to its essentials, I think they are the kind of fair information practice principles, these FIPS, or what you find in Article 5 of the GDPR. These are the constant across data protection frameworks globally, the OECD, APEC, African Union Convention, you find them everywhere. And already a few years ago, the Future of Privacy Forum had published a report on automated decision-making where they highlighted that although at the time the GDPR was being adopted, there was a lot of attention being placed and emphasis being placed on the kind of algorithmic due process provisions of the GDPR, so around right to explanation, the prohibition on automated decision-making. In practice, what you could see through the decisional practice of the supervisory authorities was that these principles were being invoked in order to put in place those kind of safeguards or guardrails around the use of automated decision-making systems in different contexts, ranging from things like the use of facial recognition technologies in schools, to serve school meals, to all kinds of other situations where these principles were being invoked to have a quite significant impact. And I think if you start to look also at the Court of Justice case law and the statements of the EDPB around this, you see that these principles are becoming far more developed and potentially more potent when it comes to AI. So fairness, for example, we're told is a principle of non-exploitation. If you look at something like the guidelines on data protection by design or by default, and that kind of non-exploitation principle has the potential to scale, I think, to the kind of power concerns that Woody was raising. We see recent case law around the principle of accuracy coming from the Court of Justice of the EU, which has been very instrumental in upholding and respecting trans rights around accurate references to someone's preferred gender identity. We also see recently, just last week or the week before, a decision from the Brussels Market Court declaring the TCF consent and transparency framework string to be incompatible with GDPR, in part because of security and integrity concerns. And so I think these principles can be flexible, can be adapted to apply effectively to AI systems. The caveat, I think, to this is kind of twofold. First of all, we are only, for some people, in some people's opinion, kind of tinkering at the edges. You're not going directly to target specific business models. You are instead ensuring that those business models are put to market in a way that is as proportionate as possible. And so a lot hinges here on how you interpret concepts like necessity that you find in these principles. So is the data processing necessary to achieve a specific purpose? If your bar for necessity is quite low from a legal perspective, meaning it is desirable, for instance, or cost effective in order to process personal data for these purposes, that won't offer much by way of fundamental rights protection. However, if your threshold for necessity is quite high, following something like the Meta Platforms judgment from the Court of Justice of the EU, where the court says that necessity means there is no other alternative means available, so it's indispensable to achieve a certain objective, then this can have kind of a more significant fundamental rights impact. The next feature I want to talk about is the diversified enforcement of the GDPR. So obviously this has been a bit of a bugbear in recent years. The decentralized system of enforcement has caused all sorts of, let's call them diplomatically, teething problems, and has been the subject of a lot of criticism. Yet, and I wonder what US colleagues think of this, coming from a federal system, one potential merit of this diversified enforcement is that there's no kind of single choke point or cut-off point for regulatory capture. So there's no single pressure point where companies can apply a lot of pressure and succeed across Europe. And I think you see that in some of the EDPB consistency decisions where divergent opinions of the Irish Supervisory Authority are effectively overruled by the majority opinion of other supervisory authorities in Europe, like in WhatsApp and Meta and other cases. But also, I think the fact that we are giving rights to individuals to bring actions, civil society could potentially bring representative actions, you have actions of regulators, you have actions before courts. This obviously causes complexity, but it gives us a lot of ways in to challenge automated systems. And if you compare that to something like the EU's AI Act, there are essentially no ways for individuals to challenge systems that have been put on the market in a way that is kind of incompatible with the provisions of the AI Act. And so I think that's a feature of the GDPR that will become increasingly important. The last point I want to talk about is just this idea that the GDPR is individualistic in nature. And this is, I think, the main critique of the GDPR when its application to AI systems is discussed. And there's been a huge amount of important academic work on this topic, historically by feminist scholars like Anita Allen, but more recently in the EU context by Katie Nolan, Felix Beeker, Susanna Lindros-Hovenheimer, and many others. And I think we have kind of diagnosed the problems quite effectively. These are the kind of information and power asymmetries that Woody mentioned, all of the ways in which individual control might be practically difficult in a digitized and networked environment. But there's also that kind of conceptual challenge that Claire mentioned, which is this relational dimension of personal data. And so the idea that data about me, or even synthetic data, could be used to make inferences about others, challenges a lot of the individual rights, for example, the way in which we allocate individual rights to people in relation to their data under systems like the GDPR. But I think that what data protection scholars, privacy scholars, or this community, has, myself included, have been less adept at thinking about so far is what it would mean to move away from this individualistic approach to personal data protection. The main risk I see here is that we have a wholesale transfer of rights from individuals to entities who will process personal data in ways that is not necessarily in the public interest. So how, kind of given the prevailing political economy, would we ensure that any transfer of rights away from individuals, if it was desirable, would be done in a way that was kind of rights respecting? So I think that's, you know, the first and the major challenge here. I do think, and this is one of the conclusions of Katie Nolan's thesis at the LSE as well, that data protection law doesn't necessarily have to be individualistic in nature. We have Article 16 of the TFEU and Article 8 of the EU Charter, which kind of set out a legal basis to enact data protection laws, and that has been used to enact other legislation, like elements of the AI Act, which are not individualistic in nature. So we're not locked into this individualistic framework. But I think before we kind of throw out the baby with the bathwater, it's necessary to think about what alternative models for data governance would look like if we moved beyond individuals. And, you know, my reflections on this are fairly simplistic, but at the moment, a lot of the ways in which we conceptualize collective data rights, so things like data trusts, data cooperatives, remain kind of rooted in individual rights in relation to data. They're simply aggregates of individual rights in relation to data. So we're not really ever tackling that conceptual question, which kind of goes to the legitimacy of who gets to say what happens with data. And, you know, I wonder if we were to think more about public interest data processing. And another risk there, or another challenge, and this I think is very much open for discussion, is we could say, well, what is the preferred approach? Would it be a kind of a majority rule approach when it comes to personal data use? And in this circumstance, for me, the main kind of drawback of that kind of majority rule approach is that minority rights could be entirely kind of overlooked in the process. And so if the aim is to protect fundamental rights, typically we would say that is of the most marginalized communities in society. If we moved to a majoritarian model, how would those minority rights be taken into play? Some thoughts on this, but this is really only being discussed at the moment under the kind of heading of participatory AI. And here, you know, it's about the involvement of marginalized communities or various stakeholders in terms of the design and the development and the deployment of AI models. But that, to me, seems to be an intervention at a different level of the system, insofar as the AI models, and when they hit the ground, is kind of downstream of the initial data collection, data gathering, data processing, which is happening upstream. And so I know people, you know, there have been many arguments that we shouldn't be kind of differentiating in this way between data processing for the development of systems and the ultimate data use. But for the moment, that's the way in which our legal framework is conceived. And so I do think we also need to think of public interest data governance as distinct from kind of participatory AI. But there are lots of questions about how we would do that in a way which respects minority rights.
Thank you. So I'm curious if any of you, before I get into some of the questions that I have prepared, have reactions to anything that you have heard. Is there a point here that you think is worth magnifying or shouting down as entirely objectionable or something in between?
Thank you. Well, first of all, thanks. This was extremely enriching and interesting. I just wanted to make maybe a couple of points indeed as a reaction. So on the issue of scale and of like how data protection law tackles tech oligarchy and so on, one thing that I'm also thinking is that we also have, for example, competition law and the DMA. So I think we kind of have to maybe look at at least for the EU, look at things like all together and kind of look at this, what we've been maybe criticizing, like kind of this patchwork of laws, but also in a positive way, because I think the digital package kind of tackles things from multiple angles. And so, yes, indeed, I think maybe the issue of scale can also be tackled by other pieces of legislation, which doesn't mean, indeed, that data protection law doesn't tackle the issue of power imbalance, as Orla was underlining. Indeed, I think the principle of fairness does touch upon this. Yeah, and on the point about self-determination and like how this can be illusory in today's world, I think, indeed, there are issues where, for example, the legal basis of consent isn't the most appropriate, but this is typically when consent isn't free and isn't informed. So I would say already the GDPR and data protection law allows for, a framework where we don't just put the burden on the individual to decide on what is being done with their own data and kind of have to understand everything and go through everything. Of course, there's this component, but there's also a component, as I was saying earlier, really putting the burden on the controllers to do well, and not harm in a way by complying with the different provisions. And then, another quick point that I wanted to make about, for example, chatbots and situations where maybe the issue doesn't come from training data, as you were saying, Claire. This is true. There can be issues that don't come from the training data set. Still, in my view, the concept of processing of personal data is so broad that actually even the interaction of the user with the chatbot, for example, to just follow up on the example you were making, does amount to processing of personal data because you're interacting and you're giving your rights in that specific instance. And so in my view, the GDPR does tackle also some, indeed, of these issues where, of the scenarios where the problem, let's say, doesn't come from the data set that is the training, but comes from processing of personal data that happens later on in the life cycle of the AI model. So just to add a few thoughts.
I might react to that briefly if it's okay. So I think the Digital Markets Act is a potentially very kind of powerful tool at tackling kind of gatekeeper power. The only thing that I think is extremely problematic about it from a data protection perspective is that it really doubles down on consent. So for each of the prohibitions that you find, for each of the requirements that are imposed on gatekeepers around data, so for example, that the obligation that the requirement that you can't have data sharing across all of the services of a particular provider, across all of Google's services, for example, they can all be overridden by the consent of the individual from a GDPR perspective. So in that sense, we've kind of legislatively doubled down on consent, and you've also seen the Court of Justice really double down on consent in the Meta Platforms case, but also by saying, which I think was certainly a shock to me, that consent is the primary legal basis in many ways, and the others are all kind of subservient to it. And so in that sense, the legislature, the court is kind of doubling down on something individualistic while the regulators are trying to achieve something far more systemic. But maybe just to pick up also on Woody's point around bans, because this is something I've also been thinking about a lot. You do have some statements from data protection regulators. I've written notes at a previous conference where it was said it is not the role of a commissioner to endorse or ban particular technologies. However, you also have a provision in the GDPR which allows regulators to impose a temporary or definitive limitation or ban on processing. And this has been really underutilized, and I think it's worth having a think about why regulators don't feel, is it legitimate, sufficiently supported maybe in making these decisions. And I suspect it's because they're kind of high-stake decisions about the availability of particular technologies or not for society, and they don't feel they have the political legitimacy to make these calls. But once these technologies are embedded in the market, it becomes even harder to kind of row back from them. And I think you see that, in the kind of fudge that the Court of Justice did around some findings around Google itself as a search engine, where it kind of starts to interpret prohibitions on sensitive personal data processing as rights because it wasn't within the responsibilities, powers and capabilities of Google to otherwise effectuate or deal with the right in question effectively.
Okay. All right. Neil wanted to ask a question, but I just wanted to jump in and agree with you a lot, Orla. I think that's exactly right. And I'll just note that this is one of the problems with consent generally, is that it's a way for regulators and lawmakers to offload the sort of moral responsibility of drawing a line, right? Because it makes sense. It's like, well, we all get to choose, right? Like what's best for all of us. And so, A, that sounds nice because it's autonomy enhancing, but B, it also allows them to avoid the sort of political cost of drawing a line in the sand. But then what that sets up is what STS scholars have known as the Collin-Ridge dilemma. And I've been thinking a lot about this. And the Collin-Ridge dilemma is the idea that when a technology is first created, lawmakers are generally reluctant to do anything about it, because who knows the wonders that the internet could bring or AI could bring. And AI agents promised a sort of whole number of bounties. And so we say, oh, well, we'll just sort of offload consent, or we'll use, a lot of sort of autonomy-enhancing things while allowing the technology to develop, because who knows what we'll get of it. But the problem is that the longer you let the technology proliferate, not only the more normalized and acclimated we become to it, but we become dependent upon it. And so by the time we sort of get around to trying to draw a line with substantive prohibitions, there's no political will for it. This is referred to, I've heard this referred to as the avocado ripeness problem, like not yet, too late, right? And that's sort of where we are here.
So that's a really interesting point about consent, and it goes back to, I think, to something that Carolina said at the very beginning about what she called the dynamic and flexible provisions in the GDPR in general and in data protection law more generally, right? So if we think about the way consent works in the GDPR, free and fairly given, voluntary, revocable, versus the way the consent works in the American system all too often, did you read the fine print, and did you, that's notice, and did you choose to use the internet or AI, and that's consent, and that's enough. And consent can have this depth, and I think to Woody's point, not just does it enable regulators, and I'm mindful we have a regulator with us, but it not only does it give regulators a pass from the political cost, it also gives regulators consent. It gives them a pass from the mental cost of actually figuring out what to do. Because that's really hard, so we'll just let people figure that out for themselves. But it's not just consent in data protection law that has this dynamism and flexibility, to use Carolina's term. We could also use the term vagueness, right? There are lots of terms here that have unknown coefficients in front of them. So necessity, we talked about. Legitimacy, legitimate interest. Reasonable, fair. How strictly should we construe these flexible terms in data protection law, right? One of the arguments that American tech companies, recently emboldened by their coziness with those in political power, have argued is that European regulatory frameworks are far too strict and far too stringent and far too freedom-reducing. Not my belief, but the belief that we hear articulated. I'm curious what people think about that. How strictly should the flexible terms of the GDPR be read, particularly since they're involved in this dance with these other regulatory documents, the AI Act, the Digital Markets Act, the Digital Services Act. I'm curious what people think.
Okay, yeah, so briefly, I also wanted to answer the point about data processing. I think the fact that a chatbot company processes data doesn't necessarily mean that data protection brings a solution to the problem.
This doesn't sound like an answer to my question.
Sorry, no. But I'm going to get there, I promise. Yeah, so in terms of the GDPR principles, I think we call them principled, but it's very misleading because actually the GDPR, the GDPR tells you what to do. And I think we have the same issue in AI law where the AI Act is also supposed to be more principle-based in certain ways. But of course, you also, you have the code of practice currently being drafted that will offer a presumption of compliance, and it also kind of tells company how to comply. I think on the one hand, it is necessary because otherwise companies are actually going to be able to avoid regulation. And on the other hand, the problem is with being too prescriptive is that technology moves very fast, and it might not be suitable in a few months or in a few years. And so I also wonder about this. And that's why I think, I mean, in my understanding of the AI office, they will very regularly update guidelines, et cetera. And I think, I mean, I'm very hopeful as to where it's going in terms of AI law on this. But this is just an uninformed opinion, because this is just a guess as to what's going to happen in the next few months.
Yeah, to reply quickly to your question about how strictly should we interpret the principles and the vague notions. Well, to some extent, or to a large extent, this is indeed what the EDPB does, you know, attempting at providing a consistent interpretation of several of these notions that, you know, lack maybe specificity in the way the legislation is drafted in itself. But as Orla was also saying, the Court of Justice has been interpreting some of these notions, I would say, for necessity in a quite strict way, but also, yes, legitimate interest has also been interpreted. And in my view, more broadly, like taking a step back from specific notions, but kind of more broadly, it's important to also bear in mind that the GDPR has two objectives. So there's also the free flow of personal data, which doesn't mean that this needs to be at the expense of the other goal, but in a way, the interpretation of the notions needs to take into account both objectives, and so needs to be proportionate, I would say, to both of them. Which is sometimes maybe why also the interpretation of the GDPR leads to solutions that are taking into account the broader context and as Orla was saying, the broader context maybe of the market is also being taken into account. So yes, this would be it. I think you also wanted to.
Well, maybe just to very briefly say, I think we should be interpreting them very strictly. And I think that's, you know, I see these as true principles, and that's one of the kind of beefs that a lot of the tech companies have with them, is that they say that they're too vague, but that's because they are designed to be flexible, designed to evolve, and you see that with principles like fairness. We used to have a very limited understanding of what interpretation of what fairness was. It was essentially just correlated to transparency. And now that, you know, we've kind of moved far beyond that in terms of the way in which it's being interpreted to give procedural and in some instances substantive protection. But also the Court of Justice has repeatedly stated that these principles give expression to a fundamental right. And so, as a result, I think that's the legal grounds or the legal foundations for saying they should be interpreted restrictively.
So maybe that is one of the, to overuse a word, fundamental differences between the American regulatory system and the European one. That given that you have this flexibility or vagueness or interpretation problem for things like consent, which can be between utter failure to object and knowing and voluntary, what Woody and I have called in some of our work, gold standard consent, or Carolina talked about necessity. Necessity can mean convenient, helpful to do something, or strictly necessary. Maybe it is the presence of the underlying fundamental rights commitments in the GDPR that gives it that stringency and gives it that meaning and gives it that resistance to being diluted by compliance frameworks or corporate interests, which raises, I think, an interesting question about the AI Act. To the extent that the AI Act is rooted in product safety, does it maybe lack that moral impetus that the GDPR has, that the GDPR has brought to bear, and I think has a lot to do with depending on your perspective, the success of the GDPR or the inconvenience of the GDPR. Did you want to add a point on this?
Yeah.
I realized I grabbed the mic from you. So.
Yeah, that's right. Very rudely, might I add. So I wanted to respond to your original question, but then maybe back up your second question, which is, I think that the principles, I'm going to say something now that goes against exactly what I said earlier. The more bright line rules we have in AI regulation generally, or I think probably data protection, the better off we'll be. That's not an argument against principles. I think that you have to have principles to create the boundaries of the bright line rules. But that the principal function of these principles should be to create highly determinate rules that do not require a lot of interpretation, because I don't know, I've been thinking about backsliding a lot lately, right? That we created these rules, you know, the fact that the GDPR is on the books is no small feat, but you have to fight to keep it, right? And if you have highly determinate rules, bright line rules, you have a little bit more resistance against, I think, the slow erosion. And so to the extent that the AI Act does that, I think it's commendable, and to the extent that it leaves it has indeterminate or vague rules and leaves room for watering down, we know that that's going to happen in certain contexts over time.
Questions from the audience?
Thank you very much, Ursula Pahl from Neub. Very interesting discussion, very interesting panel. And I was triggered by Orla saying that a student said that the GDPR is the first line of defense against AI. Definitely, I think a much better line of defense than the AI Act is and will ever be, a much better defense line than, for example, consumer protection law is. So there are not many defense lines, I would say, that we have. We also heard about the individualistic approach of the GDPR. Maybe we need a more collective, majoritarian approach, and that the GDPR principles can be effectively adopted to AI systems. So my question is really, the principles can be adapted, but what about the individual data subject rights? And we are in interesting times because, as you know, Meta announced that next week it will start to use personal data for AI training based on legitimate interest, so without the consent of data subjects. There are some interesting developments currently going on in Germany. Maybe that could be a defense against this going to happen, but if at all, it will only be on German territory. So my question is really, what can we do about data subjects' rights and upholding them in relation to AI systems and the big tech that seems to be rolling out whatever they want, despite the fact that it's probably not possible to exercise data subjects' rights any longer once your personal data have been absorbed and used for the training. So rectification, erasure, objection probably will no longer be possible. And we all know that. I think that has also been said by the companies. So how do you think that plays together? Thank you.
Yeah, what about that? Or maybe even put it a slightly different way. Does this mean that data protection law has to rule on the legitimacy of artificial intelligence processing? I'm curious what you guys think.
Just very quickly, I fully agree with you that data subject rights need to be complied with, and indeed there are some interpretative, let's say, issues that also the DPB is working on regarding the issue of data subject rights and AI training and so on. So just to say, I fully agree with the need for all data subject rights to be complied with fully, also in the context of AI. Yes.
I think if we were to be legally quite hard line on this, you would say that if a system is incapable of actually fulfilling an individual's right, then that interferes with the essence of the right. The right is extinguished in its entirety, and interferences which affect the essence of rights should be de facto disproportionate and unlawful. I would love to see some data protection authorities follow up on that reasoning, or indeed, the Court of Justice. It's used the essence a little bit in Schrems and some other judgments, but I think it has more scope in this context.
There was another hand up in the back, I think. That
it's
hand
on?
seems to have a microphone. So.
Yeah, I'm Maria Magierska from Maastricht University. Thanks so much for this panel. And I actually have a question a bit building up what Ursula was saying. But maybe from the institutional perspective. So what do you see the role for the data protection authority is now, given this dual objective of the data protection, as you were talking about, and Carolina, I think you were mentioning the need to also for the court is particularly to flag it, like this economic objective of the GDPR as well. So I was just thinking, what is the role of data protection authorities here? Should they be exclusively on the side of the data subject, or should they actually balance it as they are doing it now? But I was thinking of, like, it obviously creates particular risks on suddenly the data protection authorities will become just regulators on the other side of the compliance side. So I was wondering about that. And another thing, maybe also, if you can briefly talk about this collective potential of that is there in the GDPR, perhaps also considering the collective redress directive that could work against the AI systems violations. Yeah, I'm curious to hear your thoughts.
So that is a lot of questions for 3 minutes in our panel. But it sounds like maybe Carolina is the best person to jump in first, given that it's about the role of regulators in this new regime.
Yeah. Thank you very much. Yes, I mean, as I was saying, data protection authority's role is really that of applying and enforcing the GDPR in its fullest way. And I think, connecting to what I was saying at the very beginning, I think if we interpret the GDPR fully, it does provide a lot of protections. And I think this is what DPAs are committed to doing. And this has been very visible, I think, from the multiple cases that have been opened and launched lately on AI specifically, but also in the past more broadly on automated decision-making, as Orla was saying. So I would say DPAs have been quite active in terms of enforcement in this field. Of course, more could always be done, and I think DPAs are committed to doing this in taking into account the resource limitations, of course, as we always say and have to say, because this is the reality. But I would say, indeed, the role of data protection authorities is that of enforcing the legislation and starting with complaints from data subjects and so on. And I wouldn't say DPAs take one side or the other. I think DPAs really enforce and apply the legislation, and I wouldn't see their role as necessarily being that of a mediator between two different sides, but really trying to make sure that the GDPR is applied and enforced in a consistent way across the EEA.
Orla, did you want to?
Yeah, maybe just to say, I think that's a fantastic question, particularly in light of, the Data Governance Act, Data Act, and all of the, the kind of normative shift we're seeing around data use in Europe. Also, in the UK, for example, the regulator now, under the Data Use and Access Bill, which should be adopted next month, will have growth and competitiveness as one of its regulatory objectives. And in some ways, this is being presented as kind of business as usual. Well, we already took growth and competitiveness into account through things like legitimate interests and other things. From my perspective, in terms of the way I would interpret the GDPR, I would say that the free flow of data is conditional on respect for fundamental rights. Unless there's no free flow of data without that kind of prerequisite of fundamental rights protection. I think that's the logical way to interpret the historic development of the GDPR, and I think that's the way regulators should be approaching this, but I know that that's not necessarily always the case.
Well, final thoughts, a sentence from each panelist. How should we think about the relationship in light of this discussion, in light of what we've been talking about how far data protection should extend into this area of tech regulation generally? What are the limits of data protection?
I think my take on this is whether or not we think it's kind of conceptually desirable. Data protection law is already knee-deep in AI regulation because of specific provisions that are, algorithmic due process provisions, but also because data is a fundamental ingredient of AI systems. And so we can't extricate the two, even if we wanted to, for the sake of coherence.
I fully agree with what Orla just said. I think data protection should extend, let's say, as far as possible within its remit, and given the very broad definition that we have of processing of personal data. So I would say, indeed, we're very far in it, and the DPAs and the DPB will continue working on it very much. So yes, as far as possible.
I think if we just take a moment to think about life before the internet, I mean, technology in the past few years has been absolutely transformative. It's changed the way we work, the way we meet people, the way we love. And I think there is no framework currently that is commensurate to those deep changes to society. The attention economy, the restructuring of work and labor. I think we need much more transformative laws and to rethink the entire system, really.
I think that to the extent that we can supplement data protection with other rules, corporate governance rules, relational rules, other sorts of rules, we should. To the extent we can't, we should try to maximize the parts of data protection frameworks that focus on power and communal public interest aspects.
Well, on that cheerful note, please join me in thanking my panelists.